So Matthew, we've got a situation where we often have clients call us up and go, hey, I need legal advice. And I'll say, about what? They're like, is this confidential? I mean, is this covered? And I'm like, yeah, of course. It's all confidential. And they're like, well, I was in a relationship with my staff sergeant and I'm a commander. And I'm like, okay, inappropriate relationship stuff. We get those cases all the time. You were staff judge advocate. How many times did you see those cases as a defense counsel and a staff judge advocate?
Oh my God, dozens, at least, all the time. I mean, we're humans.
Right.
I mean, soldiers are humans too. It happens.
Right. And so there's not a UCMJ provision that says inappropriate relationship. It's incorporated through Article 92, violation of a lawful general order. And that is that the accused violated some general order. They knew it was in effect at the time, and the violation was wrongful. I guess it's 600-20, AR 600-20 that governs prohibited relationships. I think it's paragraph 4-14, but I could be wrong on that.
I think that's right.
But that's what says, hey, here's an inappropriate relationship. Here's, they don't define appropriate relationships, but they say what's inappropriate. I remember when I joined the Army, right? Back in 1996, it was okay for officers to date enlisted. It was okay. There was really not much of a prohibition unless it was in your direct chain of command. And that was it. That was the only prohibition on it. That's changed a lot.
Yeah, it has changed a lot. And I think this is an example of a lot of regulations and provisions of the Uniform Code of Military Justice where things generally, it seems like, have gotten a lot more restrictive generally over the past 10, 20 years for some reason. And to me, it seems like Congress is just trying to make it harder easier to prosecute soldiers, whether that's a regulation that's being more restrictive, or whether that's sometimes a loosening of the rules of evidence. And this is one of them, in my opinion.
Right. So what should a soldier do, or any service member, if they're facing charges or allegations of an inappropriate relationship?
Yeah. So for a lot of people, their first instinct is just start talking, defend myself, right? Hey, it's not what you think. It's something else. Or, they start talking about trying to talk themselves out of it. But really, just exercise your right to remain silent immediately. There's nothing wrong with that. It doesn't make you look guilty. It just proves that you're somebody who understands what their rights are.
Right. You should exercise your rights. You should contact a lawyer who's dealt with these cases several times, especially if you've got retirement that's on the line. You should save all the evidence that you have that shows that it's a appropriate relationship, whether those are texts, whether they're emails, whether they're anything that has to do with showing this is a traditional professional relationship. And then you should also make a list for your lawyer of everyone who's going to say, hey, I know these guys. I've never saw anything inappropriate, or I know these guys, and all I've seen is a professional relationship. You need to start building that. Under no circumstances should you contact the person you're accused of having an inappropriate relationship with. Should never happen.
So that happens a lot. So, hey, I don't know if you heard, but they're saying that you and I are doing this. So, and then they start talking about what they're going to tell authorities. I'm going to tell them this, back me up. Whatever you do, don't do that. That just makes the situation worse.
That's another crime.
It is another crime. For my clients, so Will, you mentioned, preserve evidence, texts, emails, whatever that shows that this relationship was not an inappropriate relationship. So for my clients, I want them to, even if it were an inappropriate relationship, as their attorney, I want to know that too. It doesn't mean that I'm going to approach their case any differently. I just don't like to have surprises when I have to deal with the government in this case.
Right. This isn't necessarily the topic of this particular video, but absolutely clients have to be 100% honest with their defense counsel. And as I tell them, I say, look, if I know where the bodies are buried, I can make sure that the government doesn't find those bodies.
100%. I want to know what I'm facing when I go into whatever court, a board. If I'm responding to an NCOER, I want to know exactly what I'm facing, because I'm going to put up an argument that says one thing, and if there's evidence out there that 100% disproves what I'm trying to argue, that's going to blow credibility of all of us, not just me, but you as well.
Right. So some younger lawyers don't understand the difference of putting on evidence that is false, right? Or putting on evidence that contradicts the government's theory. And some say, well, if I know the truth, how do I argue something different? You can argue whatever you want if it's supported by evidence or lack of evidence.
Yep. Yeah.
Even if you know it's untrue.
Yeah. Now, I'm not going to intentionally be misleading.
Right.
But that's why this is where experience comes into play. I know how to present that evidence in a way that it's not misleading, or maybe that piece of evidence or that direction of the case is not helpful to our case. That's okay. We're going to take the case in a different direction.
Right. So like, if I know that my client's fingerprints are on that window, right? And I know that CID did not dust that window. In my discovery request, I'm not going to say, dust that window. I want to know the prints on that window. I'm going to say, in the building across the street, I want the fingerprints off the 3rd floor, 3rd apartment.
That's right.
Because now CID is going to go, what the hell's he want that for?
What are we missing?
And they're not going to have any clue as to why I want the building across the street, fingerprints from that 3rd apartment.
That's right. I used to do the same thing in Article 32 hearings. I would argue a theory of my case that I had no intention of arguing at trial. And it's perfectly legal. It's perfectly ethical. And a lot of prosecutors and trial counsel didn't like that. They thought I was being unethical, but it's not.
No. I mean, our single duty is to our client. And unlike the government, whose responsibility is to ensure justice, our responsibility is to win.
Yeah, we're not trying to ensure justice or to make sure that you're being treated fairly. We're the opposite. We're trying to make sure that this system is very unfair for them.
Right. We want to win. And to help us win your case, we have to know the truth. I think it's real important. If you're facing an inappropriate relationship allegation, you got to be honest with your lawyers. And one of the most important things for you to do is to be the best soldier that you can, because these convening authorities or boards or even, the Army Board of Correction and Military Records, they're going to look at, here's the allegation, what happened afterwards? Because you either spiral out of control and explode, or you perform admirably and they're like, wow, look at this. When this guy's facing adversity, he rose to the level, he brought his A game.
Yeah, despite being one of the most stressful times in your career, not only did you exercise resilience and get through it, but you excelled.
Right. And that's what you have to do. Be honest with your lawyers, preserve all the evidence that you have, and then work as a team. And know that we're here to protect you at all costs. If you're facing allegations of an inappropriate relationship, give us a call. We're the law office of Will M. Helixon. We are your warrior advocates. You defend the nation. We defend you.